Imagine for a second that you are holding a vial in your hand.
Okay, vial.
Right. And inside that vial is the exact chemical recipe to cure a deadly disease. You have the laboratories to mass produce it, you have the scientists ready to go, and, there are millions of people who desperately need it.
Setting up a classic ethical dilemma here.
Exactly. But here's the catch. If you manufacture even a single pill, the government is going to send armed marshals to shut your factory down. They'll seize your assets and basically drag you into this grueling, multi-million-dollar court battle.
Yeah, and why? Because someone else, maybe a massive corporation sitting halfway across the globe, literally owns the invisible idea of that cure.
Right. They own the thought. And they have this piece of paper that gives them an absolute legally enforceable monopoly over it.
It's essentially the ultimate invisible fence.
Yeah.
I mean, you can't touch it, you can't see it, but it is one of the most powerful property boundaries on the planet.
And the stakes behind who gets to put up that fence and, what they're actually allowed to fence in, that dictates the shape of modern human progress.
Oh, absolutely. It dictates everything from healthcare to technology.
So today we are mapping out that exact landscape. We are taking a deep dive into Unit V of the Osmania University LLB 3-year degree syllabus.
Which is a fantastic framework, by the way.
It really is. Specifically, we're going deep into the Indian Patents Act of 1970. But look, if you're listening to this, you don't need to be a law student prepping for your exams to care about this stuff.
Definitely not. This isn't just some dry legal theory.
Right. This is the global architecture that determines, the price of your healthcare. It determines who controls the seeds that grow our food and even the tech inside the phone you are using to listen to this deep dive right now.
Yeah, we're really exploring the mechanics of how society tries to balance things. Rewarding human genius on one hand and the public's desperate need to access vital innovations on the other.
And that tension is just constant, isn't it?
Oh, it's a tightrope walk. And the Indian patent system in particular offers this incredible masterclass in that balancing act.
How so?
Well, it has this unique historical context and a philosophical approach that really deeply contrasts with jurisdictions like the U.S. or Europe.
Right. India is known for being pretty strict.
Exactly. India's patent law is often defined just as much by what it aggressively refuses to patent all to protect the public interest as by what it actually allows.
I love that. So to really understand that, I think we have to look at the fundamental mechanism, like what a patent actually does.
Right. Let's start at the absolute foundation.
Because we throw the word around constantly in casual conversation.
Yeah.
Oh, that's a great idea. You should patent that.
Yeah, everyone says that.
But legally, under the Act, what are we actually talking about here?
At its core, a patent is a statutory right. It's granted by the government to an inventor.
Okay.
And it provides this legally enforceable monopoly for a strictly limited period. Under the Indian Patents Act, that period is 20 years.
20 years. And when does that clock start?
The clock starts ticking the very moment you file the application. And during those 2 decades, the patentee holds the exclusive right to exclude anyone else from making, using, selling, or even importing that specific invention.
Wow. So it is a total unyielding blockade.
A complete wall.
But the government didn't just, hand out 20-year monopolies out of the goodness of their hearts. There has to be a trade-off, right?
Oh, a massive trade-off.
Yeah, because why would the state willingly allow one person or one company to completely corner the market on a highly useful technology?
So the answer actually lies in the etymology of the word itself.
Okay, hit me with the linguistics.
The word patent derives from the Latin term patere, which basically translates to lay open or to make something available for public inspection.
To lay open.
Right. This is the bedrock concept. We call it the grand bargain of intellectual property law.
The grand bargain. I like that. How does it work?
The state basically approaches the inventor and offers a deal. They say, look, we will grant you this incredibly powerful 20-year commercial monopoly.
You can get rich.
Exactly. You can use it to recoup your research costs, build an empire, get incredibly wealthy. But the price of that monopoly is absolute transparency.
Meaning you can't hide how it works.
Precisely. You must completely lay open your secret. You have to provide a written manual detailing exactly how your invention works, the precise chemistry, the mechanics, everything.
So that the public can read it and understand it?
Yes. That's the price of the ticket.
I see. So if the government didn't offer this monopoly, an inventor who figured out, say, a revolutionary new way to manufacture steel, they would just lock the factory doors.
They'd have to. It'd be a trade secret.
Right. They'd hide the machinery. Make all their workers sign strict NDAs and just keep it a secret forever.
And that is exactly the problem the system is trying to solve. I mean, think about the formula for Coca-Cola or the chemical makeup of WD-40.
Oh yeah, those are famous trade secrets.
Right. And they've been kept hidden for decades.
Because they never patented them.
Exactly. If the inventors of the airplane or the transistor had managed to keep their technologies as absolute trade secrets, taking those secrets to the grave, human progress would stall out entirely.
Every new generation would just have to reinvent the wheel.
Exactly. So by forcing the inventor to disclose the blueprints in exchange for the patent, the government ensures that human knowledge is permanently expanded.
So other scientists can read your patent, learn the underlying principles, and build the next iteration.
Yes, and the kicker is, the moment those 20 years expire, your specific invention falls permanently into the public domain. Anyone can use it.
For free.
Or free, forever.
That makes a lot of sense. But wait, 20 years seems, I don't know, it seems entirely arbitrary when you look at different industries.
It is a bit of a blunt instrument, yeah.
Right. I mean, 20 years in software is ancient history. A smartphone patent from 2 decades ago is completely useless today.
Very true.
But 20 years in pharmaceuticals. A drug company might spend 12 of those years just running clinical trials and fighting for regulatory approval before they can sell a single pill.
Which leaves them with very little time.
Exactly. They might only have 8 years of actual monopoly time left to make back billions in R&D. Doesn't a blanket 20-year rule just break down when you apply it across the board?
You've hit on a massive point of friction in global trade. The standardization of the 20-year term was largely cemented by international treaties.
Like which ones?
Primarily the TRIPS agreement, the agreement on trade-related aspects of intellectual property rights. We'll definitely dissect that more shortly.
Good, because that comes up a lot in the syllabus.
It does. But to your point, creating a sliding scale, say 5 years for software and 30 years for pharma, that would require patent offices to perfectly categorize every single invention.
Oh, I see. And modern tech is so blurry.
Exactly. Imagine the endless litigation about whether a medical device powered by an AI algorithm gets the 5-year software term or the 30-year medical term.
It would be an absolute administrative nightmare.
A total mess. So global trade organizations just settled on 20 years as the universal, albeit imperfect, baseline.
Okay, let's assume I'm okay with the 20 years. I want the monopoly.
You're ready to make the grand bargain.
I am, but I know I can't just walk into the patent office and claim I've invented like a slightly more comfortable chair.
No, definitely not.
The Unit V outline details a very rigorous standard called the triad of patentability. There are these 3 massive hurdles a concept has to clear.
Yes. Section 2 of the Patents Act defines these hurdles explicitly, and this is crucial. If your invention fails even one of these 3 tests, it is rejected.
All right, let's go through them. What's the first hurdle?
The first hurdle is novelty. The invention must be genuinely, demonstrably new.
Okay, but how new is new? Like, what if I figured out a new mechanical gear system in my garage, but I wrote a detailed blog post about it 3 years ago just to show off to my engineering buddies?
Well, I have bad news for you. The moment you hit publish on that blog post, you destroyed your own novelty.
Wait, really? Even if I'm the one who wrote it?
Yes. Indian patent law, like most jurisdictions, requires absolute global novelty.
Global novelty.
The invention cannot have been anticipated by publication in any document, anywhere in the world, nor can it have been used in the country before the date you file your application.
So they really do their homework.
Oh, the Patent Office will search academic journals, old patent databases in foreign languages, random trade magazines.
Wow.
Yeah. If they find your gear system described in like a 1980s Soviet engineering manual, your application is dead on arrival.
Yeah.
It cannot already exist in the public domain.
That is ruthless. Okay, hurdle 1. Absolute novelty. If it miraculously passes that, what is the second test?
The second test is non-obviousness, officially referred to in Section 2 as the inventive step.
Inventive step. Okay.
Right. It is not sufficient for the invention to merely be new. It must represent a significant technical advance over existing knowledge or possess significant economic significance or both.
So it actually has to be a leap forward.
Exactly. And the critical standard here is that it cannot be an obvious next step to what the law calls a person skilled in the art.
Let's pause on that phrase because I see it all the time in the materials. A person skilled in the art. That sounds incredibly subjective. Like, who actually gets to decide what is obvious?
That's a great question. It's a foundational legal fiction in patent law. It's actually quite similar to the reasonable person standard you find in tort law.
Okay, the reasonable person, so it's an archetype.
Yes, often abbreviated as faceta person, having ordinary skill in the art.
Faceta, I love that.
So if you are trying to patent a new type of chemical adhesive, the falsieta isn't some Nobel laureate in chemistry, but neither are they a layperson.
They're just a solid working chemist.
Exactly. A hypothetical, average, competent industrial chemist who has read all the standard textbooks and knows all the routine laboratory techniques.
Okay, so how does the examiner use this faceta?
The examiner looks at your new adhesive and essentially asks, if I presented the problem you're trying to solve to this average chemist, would your specific solution be immediately obvious to them based on standard knowledge?
So if I just take a known adhesive and I make it blue instead of clear, the average chemist would say, yeah, obviously you just added a blue dye. That doesn't change how the glue fundamentally works.
Exactly. There's no mental leap there.
So a blue dye wouldn't pass the inventive step.
No. Routine experimentation, swapping out well-known equivalent materials, or making a minor predictable adjustment does not qualify.
It has to have that spark.
The invention must require a genuine spark of ingenuity. It has to solve a problem in a way that makes the average expert in the field say, huh, I would have thought to do it that way.
All right, so let's say my invention is entirely novel, and it required a genuine leap of genius that the average expert wouldn't see coming.
Sounds promising.
But wait, I could invent a wildly complex, totally novel, genius-level machine that just, I don't know, spins a metal ball around for literally no reason.
A useless machine.
Yeah, it does absolutely nothing useful. Does the government reward pointless genius?
They absolutely do not. Which brings us to the third test of the triad. Industrial applicability, defined under Section 2 AC.
Industrial applicability.
Right. The invention must be capable of being made or used in an industry. It cannot exist purely as an abstract theory or a whimsical contraption without any practical utility.
So my theoretical design for a faster-than-light warp drive, even if the math is revolutionary and totally non-obvious, it fails the test because I can't actually build it in a factory today.
It fails completely.
Yeah.
Patent law is grounded in applied science, not theoretical physics.
Ah, okay.
The invention must be a tangible solution to a technical problem that can be reliably reproduced in an industrial setting.
Okay, so we have the grand bargain, the 20-year term, and the triad. Novelty, inventive step, and industrial applicability.
That's the foundation.
But the sources for this unit highlight that inventions don't just come in one flavor. There is this critical distinction in patent law between what you make and how you make it.
Yes. This is the distinction between a product patent and a process patent.
Product versus process.
And honestly, if you want to understand the modern history of the Indian economy, especially its dominance in the pharmaceutical sector, you have to understand this division.
Let's map it out then. What exactly does a product patent protect?
A product patent protects the ultimate physical article, the final, tangible result of the invention.
Give me an example.
Let's use a pharmaceutical one. If a company invents a new chemical compound that cures a specific type of migraine, and they secure a product patent for that specific molecular structure, they own the exclusive right to manufacture and sell that exact pill.
And because they own the final product, it absolutely does not matter how a competitor might try to make it, right?
Exactly. The method is irrelevant to a product patent.
So if a rival scientist goes into their lab, completely ignores the original company's manufacturing methods, and discovers an entirely different, faster and cheaper chemical pathway to synthesize that exact same migraine molecule, they still can't sell it.
That is correct. A product patent is an absolute blockade on the final article.
Wow.
Even if you use a completely novel method to arrive at the identical physical structure, you are infringing.
So the product patent is really the ultimate prize.
It's the strongest form of protection.
Okay, so what does a process patent do then?
A process patent protects the method, the sequence of operations, or the specific procedure used to create something. It protects the how, not the what.
How, not the what.
Right. It could involve a precise combination of temperature controls, a unique timeline for mixing chemical reagents, or a novel mechanical assembly line technique.
Okay, let me try a culinary analogy to cement this.
Go for it.
If I have a product patent on a specific branded chocolate lava cake, I own the physical concept of that cake. Nobody else can sell a cake with my exact molecular structure of chocolate and flour.
Correct.
But if I only have a process patent, I merely own my specific recipe and baking instructions.
Exactly. Your method.
So if a competitor figures out a completely different way to bake a cake that tastes, looks, and smells identical to my lava cake, Maybe they use some weird microwave technique instead of an oven, entirely bypassing my recipe? They haven't violated my process patent?
They have not, because they didn't use your patented method.
That is a massive
Yeah.
loophole.
It's a huge distinction. Now, to understand why this matters so much for Osmania University students studying this, we have to look back at the Indian Patents Act of 1970.
Okay, take me back to 1970.
In the decades prior, under the old colonial-era 1911 Act, India had some of the highest drug prices in the entire world
Why was that?
because multinational corporations held product patents on all the vital medicines. They locked out local competition entirely and could charge whatever they wanted.
Which is a disaster for a developing nation.
A public health crisis.
Mm-hmm.
So, following the recommendations of a very famous report, the Iyengar Committee report in 1959, the Indian government made a radical, highly controversial legislative move.
What did they do?
In the 1970 Act, India deliberately abolished product patents for food, chemicals, and pharmaceuticals.
They just got rid of him.
Entirely. They decreed that in these vital sectors, you could only ever get process patent.
Wait, let me make sure I'm getting this. If I'm a global pharma company in 1975 and I invent a life-saving antibiotic, India refuses to give me a product patent.
Correct. They will only patent the way you manufacture it.
So Indian scientists could just look at my final antibiotic, reverse engineer it, figure out a different recipe to make the exact same drug, and legally sell it for pennies.
That is exactly what happened.
That is wild.
And it was a deliberate strategy of national survival. By restricting patents to processes only, the Indian government unleashed local scientists to aggressively reverse engineer global drugs.
They must have gotten really good at finding alternative recipes.
They became the best of the world at it. They developed cheaper, alternative synthesis pathways. This policy single-handedly birthed the modern Indian pharmaceutical industry.
Transforming the country into the, what do they call it, the pharmacy of the developing world.
Exactly. Indian companies began mass-producing generic versions of critical drugs for asthma, infections, and later HIV/AIDS, and supplying them globally at a fraction of the cost.
And it was completely legal under Indian law at the time.
100% legal.
That is a staggering policy maneuver. It's essentially state-sponsored disruption of global monopolies.
It was brilliant, but that era didn't last forever. The syllabus mentions TRIPS, shifting the landscape again.
Right. The TRIPS agreement we mentioned earlier, the global powers eventually pushed back, I assume.
Hard. The creation of the World Trade Organization brought about the TRIPS agreement in 1994. TRIPS mandated a harmonized baseline for intellectual property.
What did that mean for India?
To be a member of the WTO, a country had to provide patent protection for both products and processes across all fields of technology without discrimination.
So India was forced to bring product patents back for pharmaceuticals.
Yes. India was given a transition period, but by 2005, they had fully amended the Patents Act to comply with TRIPS.
Product patents in pharma and agriculture were officially reinstated.
Which was a seismic shock to the Indian generic industry. It forced them to pivot heavily toward their own R&D rather than just reverse engineering.
But process patents still matter today, right? Even with product patents back on the table. The outline cites a specific legal battle, Hoffman-LaRoche Ltd. versus Cipla Ltd. from 2008.
Oh, process patents are still incredibly vital. In the post-TRIPS era, the Hoffman-LaRoche case, which was decided by the Delhi High Court, really cemented how robustly process patents are defended.
What happened in that case?
Roche had patented a cancer drug called erlotinib hydrochloride. Cipla, which is an Indian generic giant, produced a generic version.
Okay.
The complex legal battle heavily involved analyzing the specific chemical polymorphs and the processes used to create them.
And what did the court decide?
The court reinforced a crucial doctrine. The process of manufacturing a drug is as much a protected invention as the drug itself.
Meaning you can't just lightly tweak the process and claim it's new.
Right. If a competitor utilizes your patented sequence of chemical reactions, they are infringing regardless of minor variations in the final physical appearance of the drug. Both the product blockade and the process recipe are rigorously enforced today.
Okay, so we've established the triad of patentability, and we know you can protect the product or the process.
Right.
But here is where the Indian system draws some very hard lines in the sand. Let's assume I am an absolute genius. I have a process that is novel, non-obvious, and it works perfectly in an industrial setting.
You've cleared the triad.
I'm ready for my monopoly. But the government says, no, we don't care how brilliant this is. This subject matter is simply not allowed to be owned.
Ah, yes. Sections 3 and 4 of the Act. These detail what are called statutory exclusions.
These exclusions seem like the philosophical heart of the Indian system.
They really are. They represent boundaries where the government has decided that granting a private monopoly would be actively harmful to society, human progress, or public safety.
Let's dissect this do not enter list. The sources begin with exclusions that prevent the monopolization of abstract truths. For instance, purely mathematical methods or algorithms.
This is a profound distinction between an invention and a discovery. You do not invent calculus, you discover it.
Right.
A mathematical formula or an algorithm is considered a universal logic. It exists independent of human creation. If the government allowed a corporation to patent a fundamental mathematical equation, they would essentially be tolling the laws of physics.
Yeah, I totally understand excluding the Pythagorean theorem.
Right, that would be absurd.
But the Act explicitly excludes computer programs per se. That feels different. Software runs the entire modern infrastructure of the planet.
It does.
By excluding computer programs, isn't India refusing to protect the single largest sector of modern innovation?
This is an area of massive ongoing global friction. The rationale is that raw software code, the algorithm itself, is essentially just a series of logical and mathematical steps executed by a machine.
It's just math in disguise.
Exactly. If you allow patents on pure abstract code, a single mega corporation could patent fundamental logical operations.
Oh, wow.
Imagine if someone held a 20-year monopoly on the if logic statement, or the basic algorithm for sorting a database. It would instantly freeze all software development worldwide.
So a developer writes an incredible new app and they just have zero protection. Anyone can steal it.
Not zero protection.
Yep.
Software is heavily protected by copyright law, much like a literary work or a novel.
Oh, papi.
Right. If someone steals your exact code, you sue them for copyright infringement. But copyright only protects the specific expression, the actual lines of code you wrote. It does not protect the underlying idea or function.
A patent protects the idea.
Exactly.
Ah, I see. So if I write code for a new messaging app, copyright stops someone from literally copy-pasting my code. But a patent would stop someone from building any app that messages people in that specific way, even if they wrote their own code entirely from scratch.
Precisely. And that's why the patent is so dangerous if misapplied to software.
Yeah.
It locks down the whole concept.
But wait, is all software just completely unpatentable in India?
There is a critical caveat in the Indian law. The exclusion is for computer programs per se.
Per se, meaning by itself.
Yes. If the software is intrinsically tied to specific hardware to create a novel, tangible technical effect, that changes things.
Give me an example of a technical effect.
For instance, a specific algorithm embedded in a microchip that physically alters how a car's anti-lock braking system responds to road friction. That combined hardware-software system might be patentable. The courts look for a real-world physical output, not just data processing.
That makes sense. And the sources cite the Yahoo Inc. versus Controller of Patents case here.
Yes, that case perfectly illustrates the boundary. Yahoo attempted to patent a specific method of operating a business over the internet.
What were they trying to do?
Specifically an algorithm for ranking search results and targeting advertisements.
A classic tech business model.
Right. But the Delhi High Court, alongside the Patent Office, rejected it. They ruled that a method of doing business, even if it is executed by complex software in a computer network, remains fundamentally a business method and an algorithm per se.
And both of those are strictly excluded under Section 3.
Exactly. You cannot patent a business strategy in India.
Okay, so the next category of exclusions moves from the digital world to the natural world. Discoveries of living things or non-living substances occurring in nature.
Again, we return to discovery versus invention. If you trek deep into the Himalayas and discover a rare fungal spore that naturally produces a powerful antibiotic, you have achieved something incredible for humanity.
I'm a hero.
You are. But you did not invent the fungus. Nature did. Therefore, you cannot patent the spore itself.
But what if I take that spore back to my lab and I heavily modify its genetics, I edit its DNA so that it produces 10 times the antibiotic and can survive in a factory vat? Have I crossed the line from discovery to invention?
The sources highlight a massive contrast here with the United States. Specifically, the 1980 Supreme Court case, Diamond versus Chakrabarty.
Chakrabarty. What happened there?
It's the watershed moment in American patent law. A genetic engineer named Ananda Chakrabarty developed a bacterium derived from the Pseudomonas genus. He inserted multiple distinct plasmids into it, creating a new microorganism capable of breaking down crude oil.
Essentially an oil spill-eating bug.
Exactly. And he tried to patent the living bacteria itself.
And the U.S. Patent Office initially said no because it's a living thing, right?
Yes. But the U.S. Supreme Court overruled them in a landmark 5-4 decision. They ruled that this specific microorganism did not exist anywhere in nature. It was entirely the product of human ingenuity.
Oh, wow. So they allowed a patent on life.
They did. The court
Wow.
famously declared that under U.S. law, patents could cover anything under the sun that is made by man, living or not.
Does India follow that anything under the sun philosophy?
India is far more restrictive. Following TRIPS, India does allow patents for genetically modified microorganisms, provided there is substantial human intervention and clear industrial utility.
But there's a limit.
A hard limit. Section 3 explicitly and strictly excludes whole plants, whole animals, and seeds.
Why seeds?
India has a massive agrarian economy, allowing foreign corporations to patent genetically modified seeds and demand royalty payments from farmers. Every single planting season is viewed as a direct threat to food security.
And it threatens the traditional practices of millions of farmers.
Exactly. It's a non-starter in India.
That ties directly into another exclusion mentioned, traditional knowledge. Section 3P prevents the patenting of an invention which is, in effect, traditional knowledge or an aggregation of known properties of traditionally known components.
This is a defense mechanism against what is termed biopiracy.
Biopiracy.
Yes. For centuries, Indian households have used turmeric for wound healing or neem oil as a pesticide. In the 1990s, foreign researchers attempted to extract the active compounds from these biological resources and patent their healing properties in the U.S. and Europe.
Claiming them as novel inventions.
Yes.
So they basically read ancient Ayurvedic texts, went to a Western patent office, and said, "Look what we invented."
Precisely. And the Indian government had to spend millions fighting these patents in international courts to prove that the knowledge already existed in the public domain.
That must have been infuriating.
It was. So to prevent this internally, Section 3P ensures that no one can monopolize traditional knowledge by just dressing it up in modern scientific jargon.
Okay, the outline also mentions exclusions based on public order and morality, like atomic energy, which makes obvious national security sense.
Right, nobody gets to own the atom bomb recipe.
But there is a specific medical exclusion that really caught my eye. Methods of medical treatment or surgery for humans and animals.
This exclusion is driven by pure medical ethics. Imagine a brilliant cardiothoracic surgeon develops a revolutionary new way to bypass an artery during open-heart surgery, cutting the mortality rate in half.
Under normal patent logic, they should get a 20-year monopoly on that method.
But imagine the real-world consequence. A patient is dying on an operating table. A surgeon needs to use that exact bypass method to save their life.
Oh, no.
If the method is patented, the surgeon would theoretically have to stop the operation, contact the patent holder, and negotiate a licensing fee before making the incision.
The threat of patent infringement lawsuits would just hang over every emergency room in the country.
Exactly. Therefore, Indian law categorically dictates that the physical act of medical treatment, therapy, or surgery cannot be patented.
To clarify, the doctor can patent a new scalpel they invented, or a new pacemaker, right? Those are physical products with industrial applicability.
Yes, exactly.
But they cannot patent the procedure of how the scalpel is actually used on the human body.
You've got it. The tools are patentable. The physical act of healing is not.
That brings us to what the sources treat as the absolute crown jewel of the Indian exclusions. The provision that has caused the most friction with multinational pharmaceutical companies. Section 3D.
Section 3D.
The outline calls it the loophole closer for evergreening. How exactly does a drug patent stay green forever?
We need to look at the life cycle of a blockbuster drug. Let's say a pharma company invents a brilliant new molecule to treat diabetes. They get a 20-year product patent.
Okay, the clock is ticking.
They spend a decade on trials, and then they make billions selling it for the remaining 10 years. But as year 20 approaches, they face what the industry calls the patent cliff.
The cliff. What happens at the bottom?
The moment the patent expires, generic manufacturers will legally reverse engineer the drug, flood the market with cheap alternatives, and the original company's revenue will instantly evaporate.
So the original company has a massive financial incentive to prevent that 20-year clock from ever hitting zero.
Exactly. But they can't just ask the government for more time. The limit is 20 years.
So what do?
They use chemistry to reset the clock. As the original patent nears expiration, the company takes the exact same base molecule and makes a microscopic, often trivial alteration.
Like what kind of alteration?
They might change it from a tablet into a capsule. They might attach a different salt molecule to it to make it dissolve slightly faster in a glass of water. Or they might isolate a specific crystalline structure of the powder.
Just tiny physical changes.
Right. They then march back into the patent office and say, behold,
Hmm.
a brand new invention. We need a fresh 20-year monopoly on this new version.
And because they shift all the patients to the new version and heavily market it, they effectively lock out the generic competitors from the market indefinitely.
That is evergreening. It stifles true innovation by rewarding companies for endlessly tweaking old formulas rather than inventing genuinely new cures.
I can see why lawmakers would hate that.
When India updated its laws to allow pharmaceutical product patents in 2005 under TRIPS, they were terrified of evergreening. So they drafted Section 3.
What does 3 say?
It explicitly states that the mere discovery of a new form of a known substance does not result in a new product and is therefore not patentable, unless that new form results in the enhancement of the known efficacy of that substance.
Efficacy, meaning it has to actually work better as a medicine?
Yes. The Supreme Court later defined efficacy in this context strictly as therapeutic efficacy.
Therapeutic efficacy.
If your new salt form of the drug is just more stable on a warehouse shelf or slightly easier to manufacture, that is not enough. It must actually cure the disease better or significantly reduce toxic side effects in the patient.
And this specific clause triggered one of the most famous legal battles in pharmaceutical history, the Novartis case.
Oh, yes. Novartis AG versus Union of India, decided by the Supreme Court in 2013. This was the ultimate stress test of Section 3.
Set the scene for us.
Novartis, a Swiss multinational, had developed a revolutionary drug for chronic myeloid leukemia called Gleevec. The active molecule is imatinib. Now, the base molecule was invented in the 1990s before India allowed product patents.
So the base molecule was essentially in the public domain in India. Indian generic companies were probably already manufacturing cheap versions of imatinib.
Correct. But in 2006, Novartis applied for an Indian patent not on the base molecule but on a specific polymorph, the beta-crystalline form of imatinib mesylate.
The beta crystal.
Right. They argued that this specific crystal structure was new, non-obvious, and absorbed better into the bloodstream than the older alpha form. Therefore, they claimed it was a novel invention deserving a 20-year monopoly.
How did the Indian Patent Office respond to that?
They rejected it. They applied Section 3. Yeah, they looked at the beta crystal and said, yes, it's a new physical form of a known substance. But does it show significantly enhanced therapeutic efficacy?
Does it actually cure leukemia better than the base molecule?
Exactly. The Patent Office concluded that a change in bioavailability, how quickly it absorbs, is just a physical property change. It did not prove a significant enhancement in actual therapeutic healing.
And Novartis didn't just accept that, I assume.
No, Novartis fought this rejection for 7 years, all the way to the Supreme Court of India.
Because if Novartis wins, they essentially kill Section 3D and open the floodgates for evergreening in India.
Yes.
But if India wins, Novartis loses the monopoly on one of their most profitable drugs in a market of 1 billion people.
The stakes were astronomical. Ultimately, the Supreme Court delivered a crushing defeat to Novartis. They upheld the rejection.
Wow.
They ruled meticulously that minor incremental innovations designed solely to extend monopolies without providing genuine, provable therapeutic improvement to the patient are excluded under Section 3D.
That is a monumental victory for global public health.
It really was. It ensured that the Indian generic industry could continue providing affordable, life-saving leukemia medication to patients across the developing world without infringing on a trivial patent extension.
That perfectly illustrates how the exclusions aren't just technicalities, They are profound public policy choices.
Exactly. So let's assume your invention has survived all of this.
Yeah.
It's novel, it's non-obvious, it has industrial applicability.
Okay.
It's not a math equation, it's not a surgical method, and it's not an evergreen tweak of an old drug. You are finally ready to claim your monopoly.
Which brings us to the procedural mechanics. The syllabus outlines the procedure for obtaining a patent. And the outline doesn't call it a simple application, it calls it a gauntlet.
That's an accurate term.
How difficult is it to actually get this piece of paper?
It is a grueling, highly formalized, multi-year administrative battle. You don't just fill out a form online and wait for a certificate in the mail. In India, you file your application based on territorial jurisdiction.
Where do you go?
The head office is in Kolkata, with branches in Mumbai, Chennai, and Delhi.
And what exactly am I submitting to these offices?
You begin with an application form, but
Hmm.
the absolute core of the process is the drafting of the specification.
Yeah,
This is the document where the grand bargain is executed.
right, the laying open of the secret.
You can file a provisional specification if your invention is still in the final testing phase. This acts as a placeholder, securing your priority date, proving you were the first to think of it on a specific day.
But that's just provisional.
Right. Within 12 months, you must file the complete specification.
And how detailed does this complete specification have to be? Can I just write a machine that uses magnets to generate electricity and attach a rough pencil sketch?
If you do that, your application will be instantly rejected for lack of enablement.
Enablement.
The law demands that the specification must fully and particularly describe the invention and its operation. It must disclose the best mode of performing the invention known to the applicant.
So no holding back the secret sauce.
None. It has to be written with such exacting granular precision that our hypothetical friend, the person skilled in the art, could pick up your document, walk into a workshop, and build your invention flawlessly without ever having to call you for advice.
You must lay bare every sequence, every material, every mathematical ratio.
Everything. Alongside the specification, you must submit a formalized declaration as to inventorship.
Swearing that it's mine.
Yes, swearing under penalty of perjury that you are the true and first inventor and that the invention has not been copied or stolen from another source.
Okay, I've submitted this massive technical manifesto to the patent office in Kolkata. Does a clerk just read it and stamp it approved?
Not even close. The administrative machinery kicks in. The application is published in the official patent journal, usually after 18 months. But the real trial begins when you formally request for examination.
Who looks at it then?
Your file is handed over to a specialized patent examiner. These are not general bureaucrats. They are highly trained scientists and engineers. If you invent a biotechnology process, a biotech examiner takes the file.
What is the examiner actually looking for? Are they building a prototype in the basement to see if it works?
They don't build it, no. They conduct a rigorous prior art search. They have access to global databases of every patent ever filed. Scientific literature, technical journals. Their primary job is to try and defeat your application.
Defeat it.
They scour the earth to find evidence that your invention lacks novelty or that it's obvious.
So it's an adversarial process right from the jump.
Very much so. The examiner will inevitably issue a first examination report, or FARR. This report will almost always contain objections.
What kind of objections?
They might argue that Claim 3 is too broad, or that Claim 5 is obvious based on a 1995 patent from Japan. You, usually through a registered patent agent, then have to file a detailed response.
You have to fight back.
You argue against their findings, or you amend and narrow your claims to appease them. This back-and-forth negotiation can take years.
Wow. Let's say I survive the examiner. My patent agent argues brilliantly, we narrow the claims, and the examiner finally agrees that I have a valid, novel invention. Am I done?
In many countries, you would be close. But India has a highly unique, highly democratic layer built into the procedure. It is called the pre-grant opposition.
Pre-grant opposition. What is that?
Once your application is published, but before the patent is actually granted, there is a window where any person, not just a competitor, but an NGO, a patient advocacy group, or just a concerned citizen, can file a formal opposition to your patent.
It's literally like that moment at a wedding where the officiant says, speak now or forever hold your peace.
That is a perfect structural comparison.
The government is pausing the ceremony to see if anyone in the audience has a problem with the union.
And the philosophy behind it is deeply pragmatic. The government recognizes that a single patent examiner, no matter how skilled, is not omniscient.
Right, they can't know everything.
They might have missed a crucial piece of traditional knowledge, or they might not realize a tiny chemical tweak is actually just evergreening. So the state crowdsources the policing of patents.
Give me a real-world scenario of how this plays out.
Imagine you were a major pharma company trying to patent a slight variation of an HIV drug. The examiner approves it. But an Indian generic manufacturer who has been quietly developing their own version of the base drug sees your application in the journal.
They crash the wedding.
They file a pre-grant opposition, submitting evidence that your variation lacks an inventive step and violates Section 3.
What happens then?
The controller of patents must halt the granting process, summon both parties, examine the evidence, and hold a hearing, essentially a mini-trial, before deciding whether to grant the patent or reject it.
That is intense. And if I survive the examiner and the pre-grant opposition wedding crashers, I finally get the certificate.
Yes, the patent is granted and entered into the Register of Patents. And just as a side note, there is also a post-grant opposition window where interested persons can try to revoke it within a year. But the pre-grant hurdle is the really famous one.
Okay, that is a massive technical hurdle. But here's a logistical nightmare. If I survive this multi-year gauntlet in India, I only hold a monopoly within the borders of India, right?
Correct. Patents are territorial.
What if my invention is globally revolutionary? Do I have to hire lawyers, translate my hundreds of pages of technical specifications into Japanese, German, and French, and fight patent examiners simultaneously in 50 different countries?
Historically, yes, and it was prohibitively expensive for anyone but the largest corporations. But the syllabus specifically highlights the solution to this logistical nightmare: the PCT procedure.
The Patent Cooperation Treaty, how does it simplify the chaos?
The PCT, administered by the World Intellectual Property Organization, or WIPO, does not grant an international patent. There's no single patent that covers the whole globe.
Okay.
However, it provides a unified, streamlined procedure for filing your application internationally.
Walk me through the mechanics of that.
You file a single international application under the PCT in one language, paying one initial set of fees at your local receiving office, say, the Indian Patent Office.
What does that do?
This single filing acts as a valid placeholder application in over 150 member countries simultaneously. An international searching authority will conduct a preliminary prior art search and give you a written opinion on whether your invention looks patentable.
What's the strategic advantage there? Why not just file in the countries directly?
Time and money. The PCT process buys you an extended window, usually 30 or 31 months from your initial filing date, before you have to enter the national phase.
The national phase being the moment you actually have to pay the expensive local lawyers in Japan and Germany.
Exactly. It acts as a massive global pause button. You get 2.5 years to test the market, seek out venture capital, and review the international search report.
That's huge.
If the search report shows your invention is probably obvious, you can abandon the process before spending millions on foreign lawyers. If it looks strong, you can use that time to secure funding to pay for the national phase entries. It is a vital tool for modern inventors.
All right. Let's assume the gauntlet is completely behind me. The international strategy is set. I finally hold the Indian patent certificate with the official seal.
Congratulations.
Thank you. But what actual tangible powers does this piece of paper grant me?
We enter the realm of rights and remedies of a patentee. Section 48 of the Act confers the exclusionary rights we discussed.
Right, the blockade.
If it's a product, you have the right to prevent third parties from making, using, offering for sale, selling, or importing that product. If it's a process, you can prevent them from using that process and, crucially, from selling the product obtained directly by that process.
I am the absolute king of the castle. But practically speaking, I'm an engineer. I invented a revolutionary new battery chemistry in my lab.
Okay.
I do not have $2 billion to build a gigafactory to manufacture millions of batteries. How do I actually monetize this right?
This brings us to the right to assign and license. Your patent is a piece of property, and just like real estate, you can sell it or rent it out.
How does an assignment work?
An assignment is essentially selling the house. You transfer all your rights, title, and interest to a third party, say a major tech corporation, for a lump sum. They become the new patentee.
And what is a license?
A license is renting the house. You retain ownership, but you grant the corporation the legal permission to manufacture and sell your batteries. In exchange, they agree to pay you a royalty, perhaps a flat fee, or 5% of the revenue on every single battery they sell.
Let me test the legal rigidity here. I meet the CEO of a battery company at a convention. We agree to a licensing deal over a few drinks.
Sounds risky.
We write down 5% royalties for the right to build the battery on a napkin. Both sign it, and I hand over the blueprints. 6 months later, they've made millions, and they refuse to pay me. I take my napkin to a judge. Does it hold up?
The judge will throw your case out instantly.
Really, even with signatures?
Intellectual property law disguises informality. Section 68 of the Act explicitly mandates that any assignment or license must be reduced to writing, embodying all the terms and conditions. Furthermore, it must be officially registered with the controller of patents.
Why does the government care if I register it as long as we have contract?
Because a patent is a monopoly enforced against the public. The public has an absolute right to look at the Register of Patents and know exactly who holds the power to sue them at any given moment.
Oh, that makes sense.
If the battery company starts suing smaller competitors for infringement, claiming they have an exclusive license, but that license isn't registered, the court won't recognize their legal standing. Without registration, the document is not admitted as evidence of title.
Transparency is mandatory. Now let's talk about the ultimate weapon. Infringement.
The enforcement side.
I've registered everything properly, but I go online and see a competitor selling a blatant, exact knockoff of my battery. What are my remedies?
You institute a suit for infringement, generally starting at the district court level, though high-value cases often move to the high courts. The remedies available are devastating to the infringer. The most immediate and powerful weapon is the injunction.
What does an injunction actually look like on the ground?
A court issues a binding legal order demanding the infringer cease all manufacturing and sales immediately. Court-appointed commissioners can physically enter the infringer's factories, seize the knockoff products, and confiscate the machinery used to make them.
They literally take the machines.
It halts a business overnight.
And what about the money they already made stealing my idea?
You can claim monetary compensation through two avenues: damages or an account of profits.
What's the difference?
Damages aim to compensate you for your actual losses, the sales you missed out on because they stole your market share, or the royalty they should have paid you.
Okay, an account of profits.
An account of profits forces the infringer to open their financial books, calculate exactly how much illegal profit they made from your invention, and hand every single rupee of that profit over to you.
Absolute unmitigated power. I can shut down factories and drain bank accounts.
Yes. But, as we established at the beginning, the Indian system is profoundly skeptical of absolute power.
Which brings us to the catch.
Exactly. This is the final and perhaps most vital section of our deep dive: the limitations, obligations, and the ultimate safety valve known as compulsory licensing.
The government giveth, and the government can taketh away.
Exactly. A patent is not just a bundle of rights. It imposes heavy obligations. First, a mundane but critical one: the duty to pay renewal fees.
The maintenance fee.
Right? If you forget to pay the annual maintenance fees to the patent office, your patent ceases to exist and falls immediately into the public domain.
So I can't just get the certificate, put it in a drawer, and forget about it.
No. Furthermore, there is a fundamental obligation that the invention must be worked in India.
Worked, meaning manufactured.
Yes. The government did not grant you a monopoly just so you could put the patent in a safe and block competitors from the market, a practice known as patent hoarding. The invention must be utilized to benefit the public.
What happens if the government themselves need my invention? Say I invent a radical new radar jamming system and the military desperately wants it.
The Act contains broad provisions for government use and acquisition. The state can use your patented invention for its own purposes without your consent.
Just take it.
Yes. If it's vital for national defense, the controller can issue secrecy directions, completely prohibiting the publication of your patent to keep it out of enemy hands.
Wow.
The central government can even outright acquire your patent, transferring ownership to the state and paying you what they deem to be suitable compensation. You don't get to say no.
Okay, defense makes sense. But let's look at the civilian sector. Let's say I invent a brilliant new water purification system. Millions of people lack clean water. But I decide I want to be a billionaire, so I price my purifier at $10,000 a unit. Only the ultra-rich can afford it. It's not a defense issue, it's just pure greed. Can the government intervene?
They absolutely can, and this is the crux of the Indian patent philosophy. If a patent fails to meet the reasonable requirements of the public, the government can revoke the patent entirely.
Just cancel it.
But before taking that nuclear option, they utilize Section 84, compulsory licensing.
Compulsory licensing. That phrase sends shivers down the spine of every multinational corporation. Walk me through the mechanics of Section 84.
A compulsory license is an authorization granted by the controller of patents to a third party. It allows them to make, use, or sell a patented invention without the consent of the original patent owner.
It is a false license.
Exactly.
How does that get triggered? Can a competitor just walk in and demand by technology?
No, the threshold is exceptionally high. After 3 years from the grant of the patent, any interested person can apply for a compulsory license. But they must prove with hard evidence that at least one of 3 specific conditions is actively failing.
What are the conditions?
First, that the reasonable requirements of the public with respect to the patented invention have not been satisfied. Second, that the patented invention is not available to the public at a reasonably affordable price. Or third, that the patented invention is not being worked in the territory of India.
Let's stretch the concept here to make sure we understand the leverage.
Okay.
Imagine you engineer a structurally magnificent toll bridge over a highly dangerous, vital river crossing. You hold the patent on the structural design. It's the only safe way across.
Okay, I hold the bridge patent.
But instead of charging a normal toll, you decide to charge $5,000 per car. The vast majority of the public is stuck on the riverbank, unable to cross.
A huge public problem.
Right. So the government steps in, looks at your $5,000 toll, and says, the public requirement is not being met at an affordable price. So the state invokes compulsory licensing.
Well, what do they do to my bridge?
They legally force open your gates, allow other operators to manage the traffic, and they mandate that you will receive a fixed standard royalty, say 5% of a normal $5 toll, whether you like it or not.
Okay, I see where you're going.
You still own the patent, you still get a baseline payment, but your absolute monopoly control over the price and access is stripped away because public necessity has superseded your right to maximize profit.
The mechanics of your toll bridge scenario perfectly mirror how Section 84 operates. And this isn't merely a theoretical threat kept in a dusty law book. It was deployed in 2012 in a case that altered the global pharmaceutical landscape. Natco Pharma Ltd. versus Bayer Corporation.
The syllabus specifically highlights this case. Break down the stakes for us.
Bayer, a massive multinational pharmaceutical giant, held an Indian patent on a compound called sorafenib tosylate. They marketed it under the brand name Nexivar.
What did the drug do?
It was a life-saving, critically important drug used to treat advanced stages of kidney and liver cancer.
A literal matter of life and death for patients.
Absolutely. Bayer was legally selling Nexivar in India. However, they priced a single month's therapy at approximately 2.8 lakh rupees. At the time, that was roughly $5,500 a month.
For a single month, in a country where the median annual income was a fraction of that, that means the drug essentially didn't exist for 99% of the population.
It was catastrophically unaffordable. Furthermore, Bayer was not manufacturing the drug in India. They were importing it in tiny quantities. Evidence showed they were reaching barely 2% of the eligible patient population.
So they hit two of the failing conditions right there.
Exactly. Enter Natco Pharma, an aggressive Indian generic drug manufacturer. Natco approached the controller of patents and applied for a compulsory license under Section 84.
Natco had to prove those conditions. How did they argue it?
They systematically demolished Bayer's monopoly justification. First, they proved the reasonable requirements of the public were not met, pointing to the abysmal 2% reach.
Right.
Second, they argued 2.8 lakh rupees was objectively not a reasonably affordable price. Third, they highlighted that Bayer wasn't working the patent in India through local manufacturing.
And what was Natco's solution?
Natco made a stunning proposition to the government. If you grant us this compulsory license, we will manufacture the exact same chemical formulation here in India, and we will sell a month's supply not for 2.8 lakhs, but for 8,800 rupees.
They offered to drop the price from $5,500 to about $175. That is a 97% price reduction.
It was unprecedented.
How did the patent controller navigate the legal fallout of making that call?
The controller made history. For the very first time under the modern Indian Patents Act, a compulsory license was granted. The controller ruthlessly analyzed the pricing and determined that Bayer's monopoly was actively harming the public. Natco was granted the legal right to manufacture and sell the generic version of Nexivar.
Did Bayer get anything?
Yes. Natco was ordered to pay a mandatory 6% royalty on their net sales back to Bayer to compensate for the R&D, and they were required to donate a certain amount of the drug to impoverished patients.
I can only imagine the shockwaves this sent through corporate boardrooms in the US and Europe. Big Pharma must have seen this as an existential threat.
The global blowback was immense. Multinational pharmaceutical companies argued that if a government can arbitrarily decide that a price is too high and hand the patent blueprint over to a generic rival, the core incentive to spend billions researching cancer cures is destroyed.
They argued it was state-sponsored theft.
Exactly. They saw it as theft under the guise of public health.
And India's counterargument.
India's counterargument strikes at the very soul of intellectual property jurisprudence. A patent is not an absolute divine right. It is a temporary privilege granted by the sovereign state.
And the purpose of that privilege.
To advance human society.
Hmm.
If that privilege is warped into a tool that allows a corporation to extract maximum global profit at the literal cost of citizens dying because they cannot afford the toll bridge, the state has a moral and legal duty to shatter the monopoly.
That is powerful.
The Natco versus Bayer decision sent a clear message to the world. Intellectual property rights are fundamental to innovation, but they are forever secondary to human survival.
That brings us full circle. That is the true weight of the grand bargain. It is a constant, high-wire balancing act between the inventor's right to profit and the public's right to survive and progress.
Precisely. That is the essence of Unity.
Let's pull the lens back and summarize the incredible legal architecture we've explored today. We started with the foundational concept of patentee, the absolute necessity of laying open your secret to the world in exchange for a 20-year exclusionary monopoly.
We rigorously tested the triad, demanding absolute novelty, a non-obvious inventive leap by a person skilled in the art, and tangible industrial applicability.
We charted the historical evolution from process-only patents that birthed India's generic industry to the TRIPS-mandated return of product patents, and how cases like Hoffman-La Roche fiercely protect both the final item and the recipe used to make it.
We navigated the strict do not enter zones of sections 3 and 4, understanding the philosophical reasons why we cannot own mathematical truths, biological discoveries, or the physical act of surgery.
And we saw how Section 3 acts as a bulwark against the evergreening of old drugs, as cemented by the Supreme Court in the Novartis battle. We walked the grueling procedural gauntlet, from the exhaustive complete specification to the pre-grant opposition and the global strategy of the PCT.
And finally, we examined the absolute power of the patentee's rights to assign, license, and seek devastating injunctions, countered immediately by the state's obligations and the ultimate safety valve of compulsory licensing, proving in Natco versus Bayer that monopolies have limits.
For everyone listening, whether you're using this as a roadmap for your law exams or you're just fascinated by how the world works, I hope we've demonstrated that patent law is not a dry collection of statutes.
It's the living, breathing code that governs human innovation.
It dictates who gets to own the future and who gets to access it. Before we sign off, I want to leave you with a provocative thought, something that takes the legal doctrines we just dissected and pushes them to the breaking point.
I'm intrigued.
Throughout this entire deep dive, the fundamental assumption has been that the inventor is a human being. The grand bargain relies on incentivizing a human mind to create. But right now, we are entering an era where artificial intelligence systems are beginning to autonomously generate novel chemical compounds for drugs.
Oh, that's a huge shift.
AI models are writing complex, functional code entirely on their own, finding solutions to engineering problems that human experts couldn't see.
Right, like the Davis case, where an AI was listed as the sole inventor. It's already testing patent offices worldwide.
Exactly. So here's the question for you to ponder. If an AI, without human intervention, invents a genuinely novel, non-obvious, industrially applicable process, who gets the patent?
The law says it has to be a person.
Right. Under the rigid text of current law, the inventor must be a person. So does the programmer who built the AI get the monopoly on an idea they never actually thought of? Does the AI itself somehow hold the property right? Or, because there was no human genius involved to incentivize, does that revolutionary invention instantly belong to the public domain, completely invisible to the fence of property law?
The laws we unpack today were built exclusively for human minds. When non-human entities begin inventing at scale, the entire foundation of the grand bargain will face an existential crisis.
It is going to be a fascinating legal collision. Thank you for joining us on this exploration. Keep questioning those invisible fences around the world. Keep looking closely at the structures that govern our ideas, and never stop learning. We'll catch you next time.